So welcome everyone to our kind of virtual coffee chat on corruption in the resources sector. We've got a number of two experts here that are going to discuss some of the recent trends and emerging issues. My name is Bethany Hipp. I'm the president of the Energy and Resources Law Association, now known as ER Law, a little bit like that show from the 90s, ER, not but ER. Is that right, Gordon?
That's correct.
Okay, ER Law. So ER Law recently changed its name from AMPLA and AMPLA Asia. I should say that I'm the president of the Asia branch of ER Law. And we recently changed the name from AMPLA Asia. And the reason for the name change was to reflect a broader range of energy issues our membership is interested in, and to reflect that expansion in membership beyond just Australia. So now we have Asia and South America are all in the fold, and maybe more expansion later on. I'll turn it briefly over to you, Gordon, who is the managing director of ER Law globally, or Australia, the main one.
Thanks, Bethany. Good morning, everyone, and good afternoon to those in Eastern Australia who are joining us as well. I just wanted to take this opportunity to welcome you to this event, and also to say just a little bit about our 2022 plans. For those of you who have attended earlier AMPLA and now ER Law virtual events, you'll be aware that these are complimentary events as part of our promotion of ER Law in Singapore. We're about to launch our ER Law Asia website, and the launch of that website will mean that it will improve the ease of access for people in, particularly in Singapore, but in ASEAN countries to attend events like this. It'll provide you with a greater access to an increased range of and number of events in both Australia and in Chile, if you're prepared to get up early enough or stay up late enough for Chilean events. And it'll also allow you to join ER Law as an international member. So keep an eye out for the launch of that website. We'll be giving you more details of that as it gets closer. We're also about to launch the 2022 Global Program. So this is a virtual program and available to all members of ER Law. Hopefully you'll be able to attend as a member next year. It's a series of 10 virtual events, but we also have a program of 3 face-to-face conferences in Sydney, Brisbane, and the annual conference in Perth. Hopefully by that time, in October, you'll be able to travel to Perth to attend that conference. And we also are hoping for a full face-to-face program in Singapore, and Bethany will provide details of that closer to the time. If you're in Australia or maybe in Chile, then as a member you'll be welcome to attend the local events that are organised there. The other thing I wanted to mention was to let you know that we're doing a bit of research at the moment into what our members and prospective members want from us. If you've registered for events in the past through AMPLA Asia or ER Law Asia, you'll have received a survey from us this week. We'd very much like you to receive your ideas so we can improve the services we provide and also the value we give to our members. So if you have 5 minutes, I'd really appreciate you taking the time to answer that survey. Bethany's reminded me that it's probably worthwhile checking your spam folder just in case it's gone in there, particularly if you didn't receive anything from us yesterday. This style of event, the coffee chat or market insights, is one of our more popular formats that we employ, and it provides a great opportunity to focus on issues which impact our industries and which may not necessarily be essentially legal in nature. So welcome to the event. I'll hand back to Bethany now, and thank you for attending.
Thanks, everyone, and thanks, Gordon. I should also mention that I think there's a prize of $500 and maybe 4 prizes of $100 for random out of a random drawing if you fill in the survey.
That's correct. Sorry, I should have mentioned that, but I didn't want to sound too commercial.
Right. I haven't filled it out yet, but I will fill it out and hopefully win. So the other, I know this is virtual, and a lot of our events this year have been virtual. Hope springs eternal that we can start doing live events again next year. We did say that last year at this time too, so we won't hold our breath. I'd also like to recognize that today is Thanksgiving in the US and for Americans around the world. Black Friday, which is traditionally the day after Thanksgiving in the US, oddly appears to be a global holiday. So happy Black Friday to everyone, and enjoy your shopping, which you can do all over the world. All right, on to our speakers. And maybe that was my second lame joke of the day, which I'll never know. So onto our speakers, Jarrod Baker, who's here with us sitting in Singapore. He's a partner at Deloitte, and he's the Southeast Asia leader for forensic investigations. He helps corporates do investigations into complex fraud, serious misconduct, and financial crimes, including corruption. He is a forensic accountant. He has experience working with regulators in the US, the UK, and Australia, and he also helps companies develop and monitor anti-bribery and corruption compliance frameworks. So welcome, Jarrod. Thanks for being here. And Ali is based in Hong Kong. He is a partner at Steptoe and Johnson, which is a Washington, D.C. headquartered law firm. His focus is on representing clients on anti-bribery and corruption, anti-money laundering, and sanctions and export controls matters in front of U.S. enforcement agencies. He has experience in financial crimes investigations, voluntary self-disclosures, and risk assessments. He frequently advises mining companies on all of these issues. So welcome, both of you. Thanks for joining us. I think we're going to have a lively discussion. This will be an informal discussion. If you have questions, you can put them in the chat, and we'll get to them as we can. We want to address any issues and questions that the participants have, so we'll be checking those, and can always we can ask Jarrod and Ali those questions. Or you can raise your hand, actually, which I might get to. I have to figure out how the Zoom works, because I'm still not very good at it. All right, so just as a brief introduction on corruption, as you all know, corruption impacts every stage of development of resource opportunities. So from obtaining exploration licenses to working with private and government partners, to the development of the resource, to sales of the commodities, and finally to the rehabilitation and end stage of the project. So there are interactions with government officials at every stage. A lot of these projects are done in developing countries where maybe corruption isn't as under control as in more developed countries, although that doesn't mean that corruption doesn't occur in the more developed countries. So coupled with that, I think that the current expectations of companies that they are good citizens and they don't contribute to poverty or environmental harm, and they practice good governance. So including ensuring they aren't contributing to corruption and misallocation of resources in the countries where they're working. I think in recent years and months, concerns are heightened with ESG focused investors, and those concerns on ESG continue to grow. That doesn't only include corruption, of course, but social value issues and environmental concerns and carbon emissions, etc. So first question, I think, and to start the discussion, we know that over the past probably 20 years, and I think the U.S. has led on this, but I think that other countries, the UK, certainly China, the EU, other countries around the globe have really taken notice of corruption in the resources sector and tried to enforce some of the rules. So maybe Ali, you can tell us a little bit more about some of those notable corruption cases in this resources industry.
Sure. Thanks, Bethany. Thanks for the introduction. Regarding Black Friday, I'd say please go out and shop, but don't shop for government officials without declaring to your friendly compliance officer first.
First joke of the day, Ali.
Okay, I hope somebody's laughing. I think I'd like to start out with what's the policy trend, right? So the biggest news from 2021 was the Biden administration came in and they made a policy statement saying that the fight against corruption is a national security threat. Really, that's been on the Democratic agenda for a while. By Democratic, I mean the Democratic Party, and really bringing anti-corruption to the forefront. And This was repeated in the policy review, and what that meant was kind of bringing a whole of government, that's the term that they use, a whole of government attitude to fighting corruption. It means not only relying on the classic method, which is the FCPA, DOJ, SEC enforcement actions, which have resulted in big fines, but are generally have been reliant on companies self-reporting and whistleblower actions, to using other mechanisms, money laundering, financial crimes reporting, using the intelligence agencies more to report to DOJ for enforcement actions. Those are all stated tools that have been that have been mentioned in this kind of new policy rewording. What that really means is that I think we will see, not immediately, but as the information starts getting pulled in, especially in the mining sector, more and more ways to bring enforcement cases, not only against those companies that are subject to the FCPA or perhaps the UK Bribery Act, but companies that act outside it, and figuring out enforcement tools that will allow US and perhaps even UK enforcement agencies to reach out. So tools like criminal money laundering, which then the US agencies can use to bring actions against non-US companies that are not subject to the FCPA if they've committed bribery and used the US financial system, use of asset forfeiture, and in some extreme cases, using OFAC as a tool to fight corruption under the new authorities under the Global Magnitsky Executive Order.
Ellie, what's the OFAC?
Office of Foreign Asset Control, which is the US agency in charge of enforcing sanctions. So typically DOJ has always done the FCPA or anti-bribery enforcement in the US, but OFAC is able to designate companies or individuals engaged in corruption, regardless of whether their corruption involves any US jurisdictional link, and therefore kind of use this extraterritorial capability to enforce US corruption rules and requirements on a global scale. And we'll see how that plays out in a case, which I thought was worth mentioning. But in the mining and commodity sector, you know, corruption is still there. There was a lot of talk that, under the Trump administration, there wasn't going to be any enforcement, but it just takes time for these things to come out. So there's a recent case for Corsa Coal, which is a Pennsylvania coal company. It's a typical, it just came out. It's a typical case where head of sales, international sales, struck up a consulting agreement with an agent to sell coal to an Egyptian state-owned entity. It was a referral fee arrangement, but there was a lot of communications behind the background where there was intent to show that this was a corrupt payment. And ultimately they ended up paying, I think the charges are that they paid the consultant about $4.8 million in commissions for $148 million worth in sales. I guess the only thing that stands out here is a lot of times in the industry, people say, 5% commissions is kind of the rule of thumb. And everybody says, well, if it's under 5%, there's nothing to worry about. That's market standard. Here it was below 5%. So 5% is no magic number. It's really if there's a corrupt intent. So you can't, in your own schemes, use some kind of rule of thumb below 5%. I don't need to look beyond. It's always you need to look beyond to see if there's a corrupt intent behind your consultancy arrangements. Veto, that was last end of 2020. They got fined $135 million. They had to pay disgorgement as well. What they were doing, they were trying to get pricing information to win fuel contracts with Petrobras. So I guess once again, it was a familiar situation where they used an intermediary agent for Petrobras deals, and they were buying Petrobras products, which is a Brazilian state-owned energy company, and they just needed to know what the right prices were for those products for their trading house, and they would get that through the agent, and then set up some fake negotiations with Petrobras officials where they'd already decided what the pricing was, but it was an elaborate scheme to cover it up. But that came to light potentially as part of the broader Petrobras investigation, and Vitol was fined for that activity. So it's not just about winning sales. If your folks are going around getting pricing information, be very careful, especially if the pricing information is how much the national oil companies or whatever mining companies selling the product at, that can land you in trouble.
And I think it would also be mindful that in China, that you'd also have state and commercial secrets issues that would arise from trying to get information that may be considered state or commercial secrets from state-owned enterprises or private enterprises as well.
Yeah, and I think this is it's easy for us to state this, like sitting here saying, oh, don't get pricing information, but a lot of times on the trading part, right, that's really where people make there's a certain amount of information that's in the market, which potentially is fine. You know, you have to judge how much you're going to buy something and how much you're going to sell something. Where you cross the line is if you're setting it up with the officials and getting non-market information directly from or through an intermediary that the government officials haven't provided anybody else, or the state-owned entity officials haven't provided anybody else, and are just providing you so you can make the right bid for the products. It's worth reminding everybody, because people always think, well, the bribes are just in the when I'm buying into a mining site or something else like that, but the pricing one is an interesting one to point out. I also noted one that's a little older. It goes back to 2016, but it goes back to corruption in the Democratic Republic of Congo. So this was a case by OXIF, which is a US investment fund, private equity fund. And they had entered into schemes and funding schemes with an Israeli businessman, Dan Gertler, whereby they would provide funding into these investment vehicles, which were owned by this Dan Gertler, who is a well-known businessman in the Congo. And those investment vehicles would then funnel money to government officials, and he was basically the conduit for doing business or getting any kind of mining rights in the DRC. So they were fined pretty heavily for that. I think 213 million from the DOJ and another 200 million from the SEC.
And is it right that Dan Gertler was under investigation and maybe was judged guilty at trial in Switzerland?
I think not Dan Gertler. That's another Israeli mining magnate, I believe.
Oh, right, Bethany Steinmetz.
Bethany Steinmetz, and that was in regard to the Simandu rights, which was, I think, between, if I recall, it was Vale. Vale got the rights from Bethany Steinmetz, but Bethany Steinmetz managed to convince the government to pull the rights from another mining company and give it to. So that's ongoing with Bethany Steinmetz. He's fighting it, but he's been found guilty in Switzerland, which is a big move on the part of the Swiss. Dan Gertler is involved in this because. So,
Ali, there seems to. Sorry, I was going to just ask a question, but carry on.
No, please go ahead.
All right. So the trends in the recent, since sort of the COVID pandemic have for enforcement actions by, it seems by almost all of the enforcement agencies, seems to be in a downward slope. Can you explain why that might be? Because there were quite a number over the 10 years prior to, increasing number of enforcement actions that seems to have slipped in recent years.
Yeah, I think the reported cases may have slipped slightly, but most of these investigations take a lot of time to come to light, right? The DOJ is doing its investigations. They're not reporting it. Some are settled without coming to light. So what we've been hearing from the officials and from DOJ itself is that the actual number of investigations that they are conducting has not dropped. It's just to look at the publicly disclosed settlements doesn't really give you an actual or good picture of what's happening on the ground. And I think the view is that the level of corruption has not decreased. I mean, I think that's a bigger issue, is with all the compliance programs globally, while major US, Australian, and UK companies might have decreased their level of corruption, in the world itself, corruption is still happening at high paces. So I think we will see enforcement. It's just, I think what we're seeing, the gap is that the current tools for enforcement do not match the practices that are happening on the ground. So we'll see it more in the way of asset forfeiture and money laundering and designations going forward.
Do you see an uptick in investigations given the large number of kind of COVID funds released by governments around the world? I suppose there might be a lag just because there's been so much money that's been floating around, and the fraud and corruption and trying to get access to that money. Jarrod, I don't know if you have anything on that, or if you've seen anything through the investigations you've been doing.
Yeah, I mean, it's certainly a risk that's out there, Bethany. But as you were alluding to, it's something I think that's going to come to light in the years to come. You know, the conduct is sort of happening now. Things are being buried, and they have to be unearthed. And that sort of, as Ali was alluding to as well, there is a lag there before these things come to the surface. Just as an example, at Deloitte, one of the things that we're advising our audit practice on from a forensic perspective is to be fully aware of, you know, when their clients are getting the government funding and the like, to be fully aware in the audit procedures about this, to make sure they're going for the right reasons and the like. So it is something that is very much top of mind.
You know, I think it's an interesting point where there is a government interest, especially, you know, at the height of COVID, the governments wanted to get masks, they wanted to get vaccines. So they were in some sense letting things go on, but unfortunately governments have time and individuals and companies don't, and governments can contradict themselves. So just because they let something pass immediately when the need was there, I don't think it necessarily translates into somebody picking up a file 2 years from now and saying, hey, what happened here? And applying those rules. So I think we'll continue. We're seeing the fraud part of it come to light already in litigation in the US, and Jarrod, you must have seen it here as well. And I think we'll see the enforcement side also, you know, once supply lines settle down, things settle down, these old cases will come to light in about 2 to 3 years.
Jarrod, are you seeing any other emerging trends in your practice in the area of corruption?
Yeah, so I mean, I obviously concur with Ali that on the investigation front, it has been slow the last few years. But, you know, there have been a couple of large matters we've had in Southeast Asia that we've been investigating on behalf of clients. But generally speaking, from a compliance perspective, I think actually that all the prior enforcement actions that have taken place, the message does appear to be sinking in, particularly for the multinational companies. You know, we're seeing a lot of corporations wanting to conduct third-party or business partner audits around the region, you know, for a variety of reasons. One, is just part of their proactive compliance, or they may have seen that a competitor company or someone else that uses that particular distributor or business partner, and there's been an issue with that company, so they just want to make sure it hasn't expanded into their organisation. From a regulatory viewpoint, in Malaysia, there was the introduction of the MHCC Act. There's been a lot of companies in Malaysia which have really wanted to lift the game, you know, very similar to what was happening with the Bribery Act 10 plus years ago. And then, you know, there's been a lot of M&A activity that's picked up, and we're sort of seeing with that it's not only the traditional background searches on the reputational side of things with the individuals and the like. And then dare I say that, when the company sort of wants you to run through a checklist to look at the compliance program. But I'm also seeing that the major PE houses now want to look at, the post-acquisition implementation, or have they got any issues that they've picked up along the way? So that's a very encouraging sign, because we used to always say to them that you've got to look at the post-acquisition side of things, and the message seems to be getting through now. A lot of other organisations we see wanting to do the compliance audits to assess the effectiveness of the program. And one of the key ways we're seeing that is that companies are very interested in learning about embedding proactive data analytics, the buzzword of artificial intelligence and things. So it's, I would say that whilst the investigation side has been slow, from a corruption standpoint, there still is a lot of work out there for us to do.
Yeah, I think, Jarrod, to that point, and third-party risks, really where the, looking at what's gone wrong in the enforcement cases and where the future is, it's not so much third-party due diligence and the onboarding. I think a lot of people now have that in hand. It's really the ongoing monitoring of your third parties. And it's also not what in your KYC files. A lot of these enforcement actions involve chats or communications by a handful of company employees with the agent regarding the scheme, right? So it's really, once you hand over the cash, whether it's a fee payment or a consultancy, and how you get your head around what is your agent doing with the money you give them, because they're not resubmitting it as an expense anymore, right? All the obvious ways of catching that are gone for companies with well-developed compliance programs, but it's still happening, and it's happening through agents just knowing what to do with the money and having a side chat with a couple of company folks. And what, under US law at least, they can impute knowledge by individuals to the company, right? And using that to bring corporate enforcement action. So the challenge for everybody is, how do I monitor my employees' emails or communications on an infrequent basis with their third-party agents, to make sure they're not saying stuff that they wouldn't say in their KYC declarations form to their compliance officer?
Are you seeing that companies are monitoring email or chat conversations to get at sort of red flags of corruption?
Yeah, so I mean, it used to happen in the trading sphere, right? A lot of that is already recorded, and the banks and the trading houses have better systems, not for corruption, but pre-existing infrastructure for that. But I think more and more folks are thinking that, listen, it's very important that all communications should be on official phone lines between the consultant and the company agents. There shouldn't be any offline. There should be, if you have any communications, you should register it in your agent system if you have it, so everybody knows what's going on. Those people are seeing that. Unfortunately, most of these things that people are doing, they're doing it after they got dinged, and the root cause analysis of why they got dinged was because they were not monitoring their employee communications with their high-risk agents. So we're not,
or that they were actually maybe bribing through their third-party agents. But
yeah, that's right. So what we're not seeing is somebody, unfortunately, wake up and say, like, hey, this seems like a great idea, and let's just do it proactively. I think it's always on the back of a big fine, where it's easier then to convince the business to spend money on that kind of enhancement. But it is worthwhile, because it's not happening in the usual ways that you would pick it up in a structured compliance system, right? Everybody knows what compliance is looking for. Everybody knows what will be the red flags, and people are structuring around that.
Yeah, I think it's really resource intensive to monitor discussions, particularly because there's so many business discussions that take place off the approved applications, email, or if there's a Yammer or one of these online, WebEx chats. So, you're looking at WebEx and WeChat and Signal and a bunch of others that are encrypted, and it's hard for companies to get at that information. So it makes it quite a complex analysis and complex activity.
Yeah, I mean, it's on that, but a lot of it is also just on company email, because folks don't think that their company email is being checked for corruption-related activity, right? So they just, I mean, they'll have stuff in there like, with, meetings with government officials and side meetings and whatever terms they like to use to describe it, but it's also just on emails. So it's really trying to get your head around how do you monitor, you can't sit on your employees' shoulders all the time, but there has to be, I think the future is going to be some kind of risk-based monitoring or keyword monitoring of employee communications.
Thank you. Any questions from the participants out there? I'm not seeing any hands raised, so I'm assuming not, but hopefully I can see the hands raised. Okay. If not, we will kind of pivot to our next topic, and that's more around the ESG and carbon related or carbon reduction related activities of many companies in the resources space. So many resources companies have announced that they've got targets for their scopes 1, 2, and 3 emissions, and committing to carbon neutrality in the decades to come. As part of those targets, they're investing in various research and projects to identify technologies that can reduce carbon emitting in the production and processing of commodities. And they are, many of the commodities that we're looking at in the resources space are very carbon emitting and do impact those both the commitments of nations and then commitments of those companies themselves. So some of these that we might be seeing are research and development agreements, collaborations with customers and with other competitors, and industry players, industry, university grants. They take a whole range of ways that research and money is being funneled into the development of technologies that can reduce carbon. So what are you seeing? And maybe I will start with you, Jarrod. What are you seeing, at least in the corruption related risks in this area?
So Bethany, I sort of break it down into 2 parts with this, is that some of the money that's put towards these programs or invested in them is not being used for the purpose it's intended, or alternatively, the money is being used as a way to try and legitimize what might be corrupt conduct. So, masking that true intent. And one of the ways I think about this, it's coming back to a very old FCPA case, but it was the one with the life sciences company that was making donations to a castle restoration fund in Poland. And where I was thinking about with that one is why would a life sciences company pay money to restore old castles in Poland? So, what was the intent behind that? And the reason was that the president or the chair of the foundation that they were making those donations to was had a senior role within the public health system in Poland and could sign off on the company's products being procured in that health system. So I use that sort of case as a backdrop around how companies need to be careful about what they're doing with these payments and what the true intent is behind them and things like that. So looking at how you can sort of reduce those risks, obviously first and foremost be around performing a risk assessment, having the right expertise there to sort of pull apart what's happening and how and where could these risks be, and then thinking about the risk mitigation activities that come into it. But then pivotal to all of this is about doing the due diligence around the key players, understanding who is involved in these programs, who are they behind, what links do they maybe have to government officials and the like. Bringing it back to that Polish example, by seeing that this gentleman was the president of the restoration fund, but he was also the senior health official, that's a massive red flag that needs to get channeled out there. I think also the key is with these agreements as well is putting the anti-corruption measures in the funding agreements, put those safeguards there. And then, you know, obviously with me being an accountant and the like, it's the accountability and transparency and the monitoring of the funds. So you know, that periodic looking at where the money is going, is it being used for the way it should be, bringing it back to the governance or the agreement that money should be going for X, Y, Z. You know, how can we check and make sure that actually has gone there? You know, that every single dollar is actually accounted for. It's a crucial way of bringing that transparency to these types of agreements.
So how do you do that? I mean, particularly, is that something that companies are using sort of legal compliance audit to do, or are they, you know, depending on the business that is driving some of these agreements, to do that after the fact monitoring? Because some of these research agreements last years, and they, you know, and I think, as you say, besides the risk of corruption, you also have the risk of fraud, or the risk that the money is just not used in a way that really achieves the goal that was set out.
Yeah. So it's both ways, Bethany, where they can look at it internally or they can bring in an external person. But, you know, I think the key is about having that right to audit within the agreement, and they can enact that right to audit. And you know, I look at it and say best practice would say that you do it periodically. You don't just do it at the end. You should do a check and balance along the way, just to see that things are moving the right way. Because as you say, these things can go on for years. But you know, I talk about what best practice would be, I guess, for a company as well. It's a risk versus reward. But you know, if they do that proper risk assessment at the start and think about what could go wrong, and have that risk mitigation plan, then it's the way to move forward.
You know, I would add to that that the business needs to drive that accountability as well, because they're the ones on the front line looking and reviewing at the product of or the technology being developed with this money and getting the reports. It shouldn't be, you know, money that's just handed over without any kind of follow-up reports or kind of assessing whether the research is good or how that research needs to change given findings or the results of the various stages. So I do think there is a business accountability that has to be driven as well as part of that, in addition maybe to some of the you know, external, internal audits and reviews and monitoring and such. And I guess I'm not saying overdo it. That sounds like there's a lot, but you know, it also has to be kind of reasonable to the risk.
That's right. But I also think that as part of that, those frontline people need to understand how the laws apply or how the risk could come into this. So that whole, you know, sort of getting together and working through when you perform that risk assessment, working through it all and certainly understand it. Because I know from experience that I guess everyone from the front line knows, you know, do not bribe, et cetera, but they may not have an appreciation of, you know, pay it and forget it or something like that. So, you know, they think that we're not the ones that are making the bribe payment or things like that. It's not, you know, we've got a legitimate purpose to want to fund this R&D. So they may not be thinking about that, oh, well, 5% got hived off to someone as a corrupt payment. They may not think that that's, you know, the fault of the company. So it really comes back to that awareness as well in the front line.
You know, Jarrod and Bethany, my question for you is with carbon offsets, etc., there's a verification part of the exercise, not just verification of the money flow, but is there an actual offset? Is the underlying activity real? And I understand that there are some third-party companies that can certify these things and provide the certifications. But is that really where a company should stop, or are there companies just using that, or are they verifying the actual offset or the underlying activity themselves, or at least on a risk-based basis?
So just to explain that a little bit further, I think, Ali, so companies make commitments in terms of their own abatement and how much carbon they can cut out from their own processes and their own emissions. And then there's, you know, the more recent, going back a number of years, of kind of voluntary carbon offsets. There's, I think, separate markets, and I'm certainly not an expert on any of these things, but but those voluntary commitments are basically buying carbon offsets, which are based on things like nature-based solutions, like a number of acres of trees planted, and then those are assigned a carbon emission reduction value, and then they can buy those carbon certificates. And there are a number of organizations that would verify those carbon emissions, and then the companies can use it to offset their own emissions. So there's also, there's a number of different kind of schemes. Scheme sounds negative, but activities in that carbon offset space where countries that can develop those offsets and then sell them to companies that need some offsetting for their own carbon emissions. And I think the due diligence on some of those is quite difficult, because you have to kind of determine whether the offset is legitimate. Granted that there are these certification companies that do that, and but then in the long term, because I think that you could say today you've got that you planted this number of trees, but what happens if the trees burn down, or if somebody cuts the trees down, or if it's sold to 2 separate companies or 5 separate companies, and so you've got one offset that really is applying to a number, and of course that doesn't help. That doesn't move the needle in terms of carbon emissions reduction overall. So question for you all is, are you seeing any of this, and what are companies doing in terms of that due diligence for this kind of carbon offset?
Yeah,
or maybe it's so emerging you're not even seeing it yet.
Well, it is emerging. Look, I break this down into 3 different parts. There's the due diligence that's got to take place at the very start, and I'll go a little bit further into that. But you've also got to review and validate the project before it kicks off, and then when it's operating, it's that assessment or that verification or that review that takes place. So, I mean, the due diligence side for me, being the forensic accountant, would be all about the reputation, integrity, track record. That's the forensic side of things. I have colleagues that deal more on how the project might work, the emissions that will be reduced, the financial viability of things. But I think what's crucial to this is that just the involvement of third parties on that. You can't just put money into it and watch it from afar. So there's got to be something there about whether you have people from your organisation go on site and do site visits and check things and walk around and talk with people. So it's not just doing this desktop review of what's taking place, but actually physically getting in there. That part 2 I was talking about with the review and the validate the project. So, someone that can properly assess the designs to ensure that's meeting your requirements and things like that. And then that third part about verifying that actually what you've paid for or what you wanted to do is actually properly happening. And again, Bethany, and I know you can't just have resources going here, there and everywhere, but if you were doing a proper third party or proper verification exercise with it, you would have a program in place where your auditors or someone is actually showing up, at these locations, whether they go to one of these once every 3 years or whatever it is, but you physically do show up and see what's going on.
Hard during COVID, of course.
Absolutely. I'm hoping COVID's behind us next year.
Yeah, hope springs eternal. Ben Smith, you had a question, I think, or maybe you wanted to correct something we said, because you have way more expertise in this area than we do.
It was more of an observation, and I maybe I'm being very naive here, but I'm just struggling slightly to see how these carbon credits could be used for sort of a corrupt scheme. But I mean, to me, bearing in mind that most of the carbon credit schemes that we see at the moment are voluntary, the real value if I'm a polluting company and I want to buy carbon credits, and I, have a scheme with somebody who's got forestry in Indonesia, for example, the value of the credits that I could get from the guy with the forest, the value to me is that those credits have been issued through a scheme, and that when I then say to my downstream customers, look, I have got some carbon credits that have been verified by whatever organization it is, the value to me of those credits is that they have been verified, and that the person that I am showing them to show that I've offset my emissions knows that they're from a verifiable scheme. So yes, I can see that there is a risk that actually the guy with the Indonesian forest does cut it down, but actually, where does that get me? I mean, yes, there's a problem with the scheme, but I'm not sure I'm going to necessarily get any benefit from giving a backhander to an I mean, if I have a bilateral scheme and I say to somebody with an Indonesian forest, look, here's some cash, say that you've not cut down the trees and you can cut them down anyway, then the value of that credit is almost nothing, because if I then try and tell someone else about it, they're going to say, well, look, I've got no way of verifying this. So I'm not quite sure, Ali, maybe you've got a specific scheme in place here, but in mind here. But,
I might just start by saying, I think this is some of the trends that people are thinking about. And I know in, what I've seen in the past is that it's not necessarily that the companies buying them are trying to be corrupt, but you get that the development of the carbon offsets, there's corruption involved in that. And then that penetrates through and limits the carbon emission offsetting that you get from the value perspective, and maybe the corruption is around what that verifying company does and whether that's sufficient to ensure that there isn't corruption in that the development of that underlying offset. But Jarrod and Ali,
I mean, certainly from my perspective, sort of advising people on the who are potentially acquiring these credits. I mean, it does seem to me quite an issue with the whole scheme that if having spent a lot of money on getting a whole load of credits, you then find out that actually whoever it is who's verifying the credits hasn't done a proper job, and the scheme turns out to be a complete sham. There does seem to be no way of getting any sort of compensation from it, or getting your money back, which strikes me as a big issue, and potentially one that could be open to corrupt purposes.
Yeah, and just a comment we've had before the panelists speak, but a comment we've had is from Lilia. Thank you, Lilia. The biggest risk with carbon credits is fraud, and UK Bribery Act risks related to the failure of internal controls. So that's something else to consider in these.
Yeah, I think that's true what Leah said, and to your question, Ben, a lot of the new forest growth, or there's a lot of programs in various developing countries, is kind of a new system where countries can grow trees and sell the offsets and raise money. A lot of that seems, when you look into it, is either government owned or owned by government officials. So you've got, say, a carbon offset scheme. So the corrupt scheme would be that if you're asked by, if you're a mining company and you're dinged by some government agency saying, or even in the agency where you're selling your product into, right? And they say, listen, because of your product, you're generating so much XYZ, we want you to offset it. And by the way, if you want to offset it, my brother owns a offset farm. Why don't you go buy credits from him? Because we want you to offset it in our country, right? There's no good for us if you create carbon dioxide in our country by selling coal or gas, but then you buy offset credit in a third country. We want you to buy the offset credit here because that's where you're polluting. But by the way, buy it from my brother. He's got a fir tree farm. That's kind of the risk when we kind of thought about it, where it would happen, and seeing who's putting money into the new forests and et cetera, is where we're seeing a potential area.
Yeah, I can see that. Thank you.
Anything further to add, Jarrod?
No, I just think, as Ali's articulating, that's where that due diligence part right up front hopefully can unearth those relationships or things happening.
Yeah.
And I think that it's, as I said, it's kind of it's because it's a newer area, and there's more and more activity in the space, and more companies are interested in buying it. I think there's, it is more of an emerging trend, and what are the risks, because the fraudsters are always going to be ahead of where the legal and compliance teams are. And so I think it's something to keep an eye on as these plans develop more and more. and as the rules for the carbon markets are developed over the next couple of years.
I mean, I guess underlying theme is that just because you're doing something good doesn't mean that there's a corruption risk associated with it, right? And I think with a lot of the green schemes and various things, people are so eager to jump into them and do it, and it's a new thing. So just like with any new product, that's when we see the compliance risk the greatest, because people don't really know how to value it, how to judge it, all these other things that you learn over time. Everybody's just now getting their hands around it and learning what they are. So that's when the emerging risks will arise with this new product.
Okay, we have a question from Lilia. That is, have you seen any new or emerging bribery risks or trends in the sector arising from implementation of new technologies such as blockchain, partnership platforms, and trading platforms?
I guess from my side, Jarrod, do you want to go first? Otherwise, I can start.
Yeah, you start, Ali, and we'll.
Yeah, from my side, I mean, the risks are on the bribery risk is that obviously using cryptocurrencies to make payments. Now, I want to park cryptocurrencies, although they are a distributed ledger technology, a DLT. There's a lot of good DLT work being done, including how to use distributed ledger technology for trade finance, because trade finance, for example, is an area that's very open to abuse, to bribery, money laundering through fictitious invoices, etc. And a lot of companies are doing work to use blockchain to kind of knock out that and verify everybody in the chain. So Lilia, I haven't seen that blockchain technology used for abuse, but I have seen it being developed to stop abuse. But cryptocurrency is the standout, because cryptocurrency continues to be used as a good way to efficiently transfer vast amounts of money, and you can put it through tumblers and all kinds of things to disguise where it's going.
And I would say, just from my perspective on trading platforms, I think probably your bigger risks on the trading platforms, other than some of the partners you might be working with, but it would be around the market manipulation on those. And I think that's something that care should be taken in some of those trading platforms. But on the corruption side, it's still around the partners you're working with, and that there's not those links to either corrupt officials or others that would be somehow manipulating things and creating some sort of benefit.
Yeah, and just from my perspective, it's something that's it's where attention is starting to be put as to how to cover these risks off from the financial crime side of things. It's I think it's obviously a key area. It's an evolving area, and Bethany, it might be a good topic for a future event.
Yeah, I do think that the cryptocurrency and the distributed and blockchain was quite a notable topic that everyone was talking about a couple of years back. I think AMPLA, the formerly AMPLA, now ER Law, we did one of the first events we did in Asia was on blockchain, and that was probably early 2019. And now I think there's probably a lot more. It's being applied more and more. And so I think you're probably right. I shouldn't be the one leading it though, because it's not my area, and I don't fully understand it, quite frankly.
I'm not sure there's a lot that do at the moment, Bethany. It's evolving.
One other, just to go back to the carbon offset, I had a comment that credits need third-party validation and verification before a project receives the carbon credit. This can be done by an independent third party or auditors, and may be susceptible to bribes and collusion to manipulate those results. So that's another corruption-related angle to those carbon offsets, and there's probably many more on that. Does anyone have any other questions from the participant group here?
Bethany, can you hear me? I think I figured out how to put my voice up. It's Lilia.
Oh, hello, Lilia. You should have joined the panel, Lilia.
Right, thank you. I still can't figure out how to put the video, but I guess the question that I had about the usage of the new technology, and we are talking about the resource sector, of course, but I guess in the banking industry where I'm coming from, we do have commodity business as well.
Yes.
And more often,
so using it to like, trace the histories from the inception or when they were dug and there's no child labor or forced labor or such. Is that that sort of use of the blockchain technologies?
Yeah, so generally blockchain technology, we see it as I would say anti-corruption development because there is a increased transparency in the blockchain. So that's a positive movement in terms of anti-corruption developments or corruption developments, risk management. What I wanted to add, one of the risks that I see is developing for us by using technology. That's a trading platform that we are establishing with new payment solutions, for example, or trading platform or any other type of things in innovative solutions. This partnership exposing us to the elevated risk because those partnership or partners from the fintech or they are not as robust companies yet. Quite often they don't even have any BC policy, bribery and corruption policy, or even code of conduct or any governance yet. So they are emerging startups, new technology companies. And quite significant part of the project goes into the upskilling the program of the anti-bribery and corruption program of the partner, starting from hiring compliance officer into the partner company, training, developing program, or helping to develop the policy and procedure, bribery and anti-bribery and corruption controls. So I just wanted to mention that that's another area where the risks are coming from.
Thank you, Lilia. And I think on the blockchain, my view, not a very educated one, but I have the platform, I'll say it. I think that where there's fraud or corruption in blockchain is at the very inception. So ab initio, then it's sort of locked into that blockchain, and so it's really hard to, because it is that distributed ledger. It's always going to be there. And I'm sure we could talk about this for a long time. And again, I'm not the expert in that area, so maybe that's an outdated view on that one. But thank you, Lilia, for that. It's important, I think, for when you're looking at these emerging technologies to make sure that there are people that understand what potential risks and emerging risks and actual risks are, and that those risks are identified and addressed. All right, well, I think that's it for this program. Thanks everyone for showing up. Thanks for the questions. Thanks for paying attention. Won't know if you paid attention because it's all virtual, but I'm just going to assume that everyone did. Thanks to the panelists, to Jarrod and Ali for a great discussion. And we will, ER-Law will be back with you next year in 2022 with a new program and hopefully some information about membership, more membership options for Asia and others. And also to note that we had a number of people from our Australia ER-Law, and so it was really great to have a more of a joined up session with the ER-Law members and participants from this APAC region. So thanks everyone. Have a great day. Happy Thanksgiving.
Thank you.
Thanks, Bethany.
Thank you all.
Thanks.
Bye.